Welcome back, Consumer Law 101 viewers. We are excited today about our part three of our ABCs of the FDCPA, which is in our advanced series of our entire video curriculum. As always, I'm your course instructor, Attorney Aaron Swift. I am the Swift Law North CEO and Managing Partner. Okay, today's agenda, we're talking about ABCs of the FDCPA, common debt collection violations. We're going to talk about 6 basic subgroups: calling and texting violations, letter, other written violations, general harassment, abuse, deception, false threats, misrepresentations, collecting false amounts, and being sued in the wrong venue. Okay, calling and texting violations. So one of the things that is not allowed is calling before 8 a.m. or after 9 p.m. So that's a very important distinction because time zones matter, of course, and debt collectors can get this wrong. So sometimes if a consumer has moved to a different time zone or the debt collector just doesn't know what time zone the consumer is in or uses the area code. Before you could trust area codes quite a bit because they translated to house phones, but now with cell phones, area codes aren't as translatable, so you can't even rely on that necessarily. So a lot of the debt collectors violate this provision by placing calls outside the allotted time frame. You can't place repeated calls to annoy, text, harass. Um, if you ask, to stop, they have to stop. If you keep doing it, that's considered repeated harassment, calls or text messages. Reg F is an important change that, again, I described earlier as bringing the law kicking and screaming into the century. And that really sets some more standards about calling, texting. For example, if a debt collector makes a successful call, you can't call the consumer again for another 7 days. Can also not try more than once every 7 days. And again, even a left voicemail is a connected call, so you can't call again for 7 days. There are other Reg F changes, but this is a very introductory course. I go into them in a lot more detail in our CL 101 for business professionals course. But nonetheless, for now, just think about new changes. You can't be called a lot. You can't be called a lot in a series of days, weeks. And you're allowed to set a convenient time and place that you want a debt collector to contact you, which is a very powerful change. Letter written violations and the first written debt collection communications, you have to give what's called the 1692G notice or the mini Miranda. It basically says this communication is from a debt collector. Any information will be used for that purpose. You have the right to dispute, this portion or any portion of the debt, so on and so forth. We'll talk about, that provision a lot later, as it's been misrepresented and manipulated wrongly into the FCRA in a lot of ways. But when a debt collector is on the scene within the first 5 days of a phone call of the first, if that's the first communication or in the first communication written, they have to give that notice. You have to also give opt-out notices, especially during, if you're getting text messages or opt-out notices for automatic phone calls. It also protects against general harassment or abuse. Of course, any four-letter words or epithets, that aren't appropriate, threats of violence or coercion. You don't see this often, but you still do. Surprisingly, these collectors are humans, and sometimes consumers get into it now and then with collecting agents, and things can go sideways. And the protections go in the consumer's favor again, especially with the standards we've talked about. Um, Another common thing is falsely implying that something's an official government action or that someone's a lawyer. You might get threats of, we're going to take you to court. Well, if that's a false threat, you can't do that. That's a problem. So let's talk about some other ones. We just segued into this one very well. A lot of debt collectors will threaten to sue and never follow up on that action. And that's a problem. You can't make false threats under the FDCPA. You're also not allowed to collect a debt that's past the statute of limitations without disclosing that fact. Statute of limitations is how long you can be sued successfully, depending on where you live or where a contract was signed. Another thing you can't do is threaten to garnish assets that are protected. For example, in Florida, you can't say, I'm going to attach a lien to your homestead property. That would be illegal because you can't do that in Florida. So that would be a false threat. Anytime you collect false amounts, whether that's an inflated balance, a fee that's not owed, contractual interest after a charge off, There's a really big recent case that involved debt collection and the Fair Credit Reporting Act about a debt collector in the apartment space who was adding false fees and got a very, very big verdict hung on them. So these are real protections that have real results in court if you actually sue to invoke them. And another one is if you've been sued in the wrong venue, the FDCPA does say that you have to be sued either where the consumer currently lives or where the contract was signed. And that, can get screwed up. Consumers move, or debt collectors just want to sue in an inconvenient place so that consumers will settle. All right, what are some best practices? We're just layering more information with you. So now you understand the purpose of the FDCPA, the who, what, and why. You also understand some standards we've talked about, least sophisticated consumer, strict liability. It's also the civil lawsuit. I will talk about that throughout these series. Civil lawsuit meaning the winner is by a preponderance of the evidence. Think a scale that just barely tips in favor, 51-49 kind of thing, which is a lower standard than criminal court by quite a bit. Um, no, but now that we've also talked about common violations, you know what to look for. If you've experienced any of these, you can fight back. If you're being harassed by a debt collector, if they're collecting amounts that aren't due, if they're calling you too much, you could be entitled to thousands of dollars. And again, the debt collector defendants, if you prevail, would have to pay your fees and costs. It's a beautiful protection. As always, we end with an invitation. If you want more information, more educational content, visit us at consumerlaw101.com. And if you think your rights have been violated, if the FDCPA has been broken, if someone has, harassed, made some false threats, or one of the other common violations we talked about today, please reach out. It's very important. We love to help consumers fight back, especially against debt collectors that are breaking the law. It's very powerful. We may be able to get the debt forgiven in a lot of instances, the trade line deleted from credit reporting, which of course is a super important, thing to a lot of consumers. And on top of that, maybe put additional money in your pocket. And again, the bad guys have to pay us. So please reach out, swiftlawnorth.com. Thanks.